The digital age has amplified misinformation, disinformation, hate speech, and privacy breaches. So Ghana's misinformation, disinformation, hate speech, and other publication of information bill 2025 seeks to protect individuals, institutions, and the state from harm caused by falsehoods and indecent expression. But there's a potential chilling effect. While aiming to safeguard public order, national security, and health, the bill risks curtailing free speech and press freedom because there are heavy sanctions that may also deter legitimate criticism, investigative journalism, and satire. Welcome to the law. We are looking at this bill, its promise and peril. We'll be right back. Welcome back. This is The Law. It's your legal light. It is your help law. And we are talking about the misinformation, disinformation, hate speech, and the publication of other information bill 2025. Now, this is a bill that has attracted a lot of commentary in the public from stakeholders, journalists, the Journalism Association, and various other, stakeholders as well have made comments. So, have you been commenting without the benefit of the bill in full? What exactly is in the bill? Have you been commenting without the benefit of what is in the misinformation, disinformation, hate speech, and publication of other information bill, which is christened MDHI Bill 2025 that the government is seeking to pass? There's a lot in the bill. It's a 90-sectioned bill organized into 8 different parts. That's a lot. So what I'm going to do is that we definitely can't use 1 hour to surgically look at the entire bill. And my copy is here. So we'll try to give you an attempt to give you a 360 of the bill, give you a fair idea of what you have in this bill, which is a draft. And then you are better informed if you have to comment, if you have to advocate in support or advocate against, you will be better informed. So I said 80 sections at the level of the drafts. Apparently, there are more than 1 draft out there in the public. So some don't have up to 80 sections. Some have, I said 90 sections. Some don't have up to 90 sections. Some have up to 90 sections. So let's begin to understand what we are dealing with when we talk about this bill. First of all, is it important? Absolutely yes. And that's the reason for my introduction. That in this digital age, we've gotten to a point where there is widespread misinformation, disinformation, and so on, and privacy breaches. And there definitely is the need to help all of us to do it and do it well. But in doing so, as I mentioned, it does appear that this bill, if it is passed in its current form, it risks a chilling effect on the freedom of speech and also of the press. So in the very first part of the bill, what it seeks to do is the object from sections 1 to 8. You have the object and you have the scope of the bill. As far as the relationships with existing laws are also concerned. Now, hold it briefly and let me explain this to you. The bill begins by telling us that there are other laws, and it mentions quite a number of them. The Cybersecurity, Act, the National Media Act, There's a National Media Commission. It mentions that act. It mentions the Data Protection Act. It mentions several other legislations, including the Criminal and Other Offences Act as well. So let me just mention the full details of the laws that it refers to. The Cybersecurity Act, the Criminal Offences Act, the National Media Commission Act, the National Communications Act, we have the Electronic Communications Act, we have the State Secret Act, the Political Parties Act 2000, and the Presidential Office Act. It's saying that the bill has a relationship, the things that are being dealt with, all these other laws have some sort of relationship with this bill. And it says that there's a need to balance the constitutional rights of speech and privacy against public interest. So the object is to protect against harm from false information, hate speech, private facts, but the scope is sweeping. It covers citizens, media, officials of the state, institutions, and it seeks to provide a certain safeguard. That safeguard is where it cautions or sort of instructs the court and a certain division, a very important division we'll talk about shortly, to balance free speech with public interest. But it brings me to ask a question. Freedom versus liability. Does protecting dignity risk silencing dissent? When we go through up to the end, you will be able to answer that question for yourself. Does protecting dignity risk, as it were, curtailing dissent or infringing on our capacity to do what the law, the parent legislation, as in the Constitution, allows us, both from the preamble of the Constitution to the Bill of Rights in Chapter 5 and then to Chapter 12 as regards media freedoms. So in the second part of the bill, after I spoke about the object and the scope, the second part of the bill deals with the institutional framework. That's from sections 9 to 16. That's where there is a very important institution that is sought to be created under the National Communications Authority, the NCA. This is supposed to be a regulator with quasi-judicial powers over speech. Take note of that. Make note of that because it's important. It has powers to investigate, establish liability, issue directives, and impose sanctions. So if you are deemed to have committed breaches of misinformation, disinformation, hate speech, and breaches of privacy rules, this division set up, if the law is passed, the bill is passed in its current form, set up under the NCA, is the institution or the division or the body that has been given wide-ranging powers to determine liability, culpability, and to give sanctions. And when you hear about some of the sanctions, you'll make the judgment for yourself. This division has supremacy. What do I mean? It has been given power so that it overrides the National Media Commission. Remember that the National Media Commission is set up by the Constitution, not an act of Parliament. The National Media Commission is set up by the Constitution. So it ought to take primacy or pride of place over and above any institution that may want to attempt to be the regulator of speech, call it content or standards. But this is being set up. It will have a director to be appointed by the president, and it will be subject to the minister's directives, the Minister of Communications directives. That's something we'll comment about. So I make an observation. This is a regulator acting as a judge and an enforcer at the same time. So are we talking about protection or political control? I said I'm trying to give you a 360 before we go into the nitty-gritty of the bill. Some aspect, because we can't do that in one show. Now, the third part of the bill, I said it's in 8 parts. The third part of the bill deals with what you call the substantive rules on information. So from section 17 to section 36, it defines what misinformation is, what disinformation is, what false information is, and then imposes a duty of due diligence, a high standard of due diligence on journalists, politicians, influencers. So before you publish anything, you have to be extremely careful. In fact, in the course, you will also discover there is supposed to be a mandatory training for media institutions and influencers and all these people. They are supposed to be certified to be able to fact check, because if you don't fact check, you'll get into trouble. The important part is that to be held liable, it must be about facts and not your opinion. So if you are dealing with facts and your facts is what is inaccurate, what is disinforming or misinforming and constituted or deemed to be hate speech, that is what it catches. It's not supposed to catch opinion. But that's a fluid thing to look at. There are specific offenses in the bill. So if you are publishing false public health information, in section 30, it says this is an offense, it is punishable. If you are publishing false election information, so it is election time, and you are making claims that are completely out of the way, which are false, facts, not opinion, you will be in trouble. Sensationalism, but not just sensationalism. Sensationalism that leads to inaccuracy. Remember, I said what is punished is facts, not opinion. Then the sanctions. Once liability is established, you'll be punished only if the public interest is harmed. Please note that. You are liable to punishment if the public interest, there's a threat of harm to the public interest, or there is harm to the public interest. So my observation is that we appear in this bill to say we're going to punish, or we are criminalizing error. When you make an error, you're going to be punished for making the error. So does this punish mistakes as much as lies? You're making a mistake, you are telling lies, you're getting into trouble. So hate speech, indecent expression, section 37 to 45, they are prohibited. There's a clear prohibition of hate speech, indecent expression. Hate speech, what is it? It includes inciting genocide or commentary that is leading to violence, which is aggravated in nature. So there was some time ago, somebody, called upon a particular tribe, to attack one other tribe. That is a clear offense that will be punished. It's a criminal offense that will be punished. And the sanction regime, you could be punished not under this law, but under the Criminal and Other Offences Act. Then under this law, the division that is set up, which I said we'll talk about, could also, issue out penalties, administrative penalties. Some of them are really very hefty. And if the punishment is to say a media house or say a telco, and they don't correct, they are being asked to make a correction or make a payment and they are not making it, every day as they continue without, as it were, correcting or remedying the error or what they have been flagged, then the amount will continue to increase. There is what the law deals as private facts and confidential information. So this is the fifth part of it. I said it's about in 8 parts, in 90 sections. Private facts and confidential information. That's between sections 46 and 55. So there's prohibition of publishing of intimate private facts, family life, health, finances. So when the law says it has a relationship with the Cybersecurity Act, with several other data protection acts, I suppose for those of you who are a little familiar, you will see that that is beginning to show. Because in the Cybersecurity Act, if you sort of did what is called cyber stalking of a child, a female, could be a female, it could be a male, but often it's the females that appear to be in danger. You could get yourself into trouble. Private facts, what we call sextortion, so that people have an affair and then they try to blackmail and say, if you don't do this to me, I will publish that video that you and I had privately, our intimate relationship. Of course, this should be punished. Nobody will say that this is something we should tolerate as a country. It should be punished. And the Cybersecurity Act punishes it. But it doesn't appear that it catches it in the fullest terms like this law is trying to do. There's a ban on publishing confidential state information. Confidential state information. There are people, who are even in government and they take an oath. They swear the oath that whenever someone is being sworn into office, you will see that they let them take the oath of that office and they make them take the oath of secrecy. And yet some of them get into some things. They disclose the things that the law says they should not disclose. So cabinet communications, investigations that are ongoing. If you are familiar with the Right to Information, Act, all of these things are protected. Economic data, emergency plans, these are not supposed to be put out in the public. If you get to be doing all of these things in this misinformation bill, if it is passed in the states that it is, you are in very deep trouble. So I mentioned hate speech, vilification, discrimination, incitement, indecent expressions. So once again, when the law says it has a relation with other laws, this becomes very obvious because indecent conduct is punished already under our Criminal and Other Offenses Act, ethnic slurs, inflammatory commentary. All right, I mentioned a bit of that a while ago. So there is liability if the disclosure is said to be offensive. There's a danger here that we will look at. If the disclosure you make of the information is offensive, is embarrassing, or is harmful to national security, the law says you will be punished. And guess what? The punishment or the liability extends to publishers. Publishers. So I am the source. Then Joy News Channel, TV is the channel. You at home listening and watching now, you are the receiver. The law will punish the channel, will punish me and punish the channel as well. So that the channel has an obligation to make sure that things that will result in embarrassment and harm to national security are not published. My observation is that privacy protection, or this is censorship. So when dignity shields power from security or scrutiny, when dignity shields power from scrutiny. Now, I've dealt with the fifth part of the law, trying to give you a 360 of it. There is the sixth part, which deals with the operational framework of the law. That's from section 56 to 62. The division I mentioned about, which we'll speak about shortly in more detail, you can take complaints to them when you feel that, publication has been made about your privacy, about your family, matters which are private and ought not to be put in the public, matters that are of the nature already prohibited or criminalized in this bill. You can make a complaint. So there are complaint procedures in there. The division has jurisdiction over all these matters, and there is an appeal process as well, which can result in the court having to resolve the matters. So when you make a complaint, they are supposed to finish dealing with everything within 10 days timeline. Very swift. It's like a fast-track court. They're supposed to deal with it within 10 days. In urgent cases, they will deal with it within 5 days. And they are very tight deadlines. You, that is the respondent. Say if there is a complaint against a media house, the media house has 2 days to respond to the petition. And then the division will make its decision. And if decisions are binding, and you may appeal, but you would have already received the sanction. So my observation is this is swift justice, or this is going to silence, voices. Now, the seventh part, I'm talking about the entire 90 sections. The seventh part, from sections 63 to 78, has to do with the sanctions and remedies. The sanctions and remedy, the sanctions regime. So the sanctions include correction. So the division can give you a correction direction. You've done something and they will correct you, or somebody has come to make a complaint and they've actually established that what you published was false or it's disinformation. They will ask you to correct. If they deem that that is the way to go about it, they will ask you to make a correction. They can ask you to stop what you are putting out. So there's a stop communication order that they can give to you. Depending on the gravity and depending on your compliance. They can also, or non-compliance, they can activate account removal. So you lose your account completely. You lose it. They will take down your account. So you can't have access, to your social media accounts anymore to be able to do anything. They can also give monetary fines. Yes, especially institutions like media organizations, the telcos, and so on. They can give monetary fines. They can issue suspension orders and suspend your license to operate. They can revoke the license they have given you, what we call the authorization license as a radio station or as a television station. Depending on the gravity and depending on your non-compliance, they can revoke the license completely. You may be due to renew the license. They could decide that they won't renew your license to you. In fact, where they mandatorily require you to undertake training in fact-checking, if you don't comply with those training requirements, they can refuse to renew your license. So you lose your license. So I say there are wide-ranging sanctions. There are wide-ranging sanctions that have implications. They could silence dissent. I look at them as speech killers. They can kill speech. So the final part, let's call that the rules affecting the stakeholders. That's from section 79 all to section 90. I mentioned already internet intermediaries are going to be regulated in Ghana now. Internet intermediaries, those who are responsible for the platforms, they are going to be regulated. And for those who are familiar with what happens elsewhere, algorithm regulation. So that will also happen here in Ghana if this is passed in its current state. Algorithm regulation is that, for example, we know that, the various social media platforms, they are made in such a way that it's algorithmic. So there's a type of information that, catches eyeballs a lot more. So you go to your social media, you post certain comments, and they don't get traction and so on, because that's how the algorithm works. Elsewhere, they try to police the algorithm and say, you are responsible for this, so you rather will be held if you don't, stop or set your algorithm this way. So it looks like there is, what I said again, there is a mandatory risk assessment and fact-checking. There are situations where national security interventions may be allowed because of the nature of the offense that is involved. Platforms, journalists become liable for user-generated content. So I asked the question, platforms are going to become censors, all right? When we talk about censorship, if the platform will be punished, then they will begin to censor, all right? Algorithms will become under state control. So is this regulation or strangulation? Now, there is this addendum to the 8th part, and it's something I find that many people who are commenting on the bill don't appear to have read it. Yes, they don't appear to have read it, including journalists. And so there are 2 repressive legislations in this country. One dates back to 1960, which is in the Act 23, the Criminal and Other Offences Act. It is the famous Section 208, that famous section which punishes, false information or false news, which has the potential not that it has caused to, it has the potential, or the law calls it, it has the likelihood to cause fear and alarm. The law you call the fear and panic law. This bill says that law, that provision, section 208, will be abolished, gone, repealed. And journalists, media stakeholders have championed many, many years since we did away with criminal libel. We did away with criminal libel in 2001. And we have said that we needed to do away with this one also, because without that, criminal libel still sits in our statute books. But it has not been done. So it's commendable that this bill seeks to repeal the infamous repressive section 208 of the Criminal and Other Offences Act. Don't go far away. That is the Abronye, law, the one that's got him into trouble. That's the law that's got a journalist just this week into trouble. He was detained beyond the 48-hour rule. That's the law. But there's another law that this law seeks to repeal, seeks to amend, not repeal, which also deserves commendation. Which law is that? That is the repressive section 76 in the Electronic Communications Act, the Electronic Communications Act, Act 775. So whilst section 208 in the Criminal and Other Offences Act punishes the publication of rumor or information which is unverified and which is likely to cause fear and alarm or disturb the public peace, whilst that law punishes that false publication with a maximum of 3 years in jail, in 2008, we passed another law, the Electronic Communications Act, and we gave similar provisions in there. And that one punishes you with up to 5 years in jail. This bill, if it is passed in its current state, that law loses its power to jail you. You will only get a fine. You will not be put into prison. And this is where the journalists around town will all shout amen, because it's been a struggle since 2001 when criminal libel was removed, seditious libel was removed from our laws. But in the end, the question I ask is, does this bill, this misinformation bill, protect us from dangerous falsehoods, or it quietly plants new seeds of censorship? That is the question we need to answer. This is the law. It's your legal light. It is your help law. And I hope I'm helping you. So this is 360 degrees of the entire 90 sections of the misinformation, disinformation, hate speech, and other publication of information bill 2025. I will take a quick break. When I return, there are a few sections that I'll take for us to have a discussion, and then we'll open the phone lines for you to join with your questions and contributions. We'll be right back. You're welcome back. This is the law. It's your legal light. It is your help law. And we're looking at the misinformation, disinformation, hate speech, and publication of other information bill 2025. It's been christened the MDHI Bill. Well, if you are looking at the full title, it shouldn't be MDHI Bill. It should then be MDHS MDHI Bill, but MDHI is fine. We can work with that. Now, because I need to bring you on, and then you may ask some very important questions, and then we'll go into the bill itself and look at certain provisions that have provide answers to your questions. I'll do this quickly, then I bring you on. So, the bill, as we have titled this show, we're looking at its promise and the perils. If you look at what the bill promises, clearly we're in a society where misinformation, disinformation, false information, hate speech is becoming very, frequent. It's no longer rare. It used to be rare. And because of social media, now today anybody can sit in any corner, any hideout. They can use pseudonyms. They don't need to use their own names. No, they don't need to use their own images. And they can spew complete falsehood and hope to get away. And the falsehood is falsehood that leads to danger, that leads to harm. It could lead to harm of individuals, could lead to harm of, the state and state institutions. So the need for it is not in doubt. But questions have been asked. There is some irony in the question that is being asked, though, because we say we do not want Section 208 of the Criminal and Other Offences Act, which says if you publish or you circulate or you spread rumor, or information that turns out to be false without verification, without checking it, and it has the potential or likelihood to cause fear and alarm or to disturb the public peace, you could go to jail for 3 years maximum. So you could go to jail for 1 day, 1 minute. Is a judge that will determine, from as low as 0.01 to 3 years. Since we have consistently said we don't want that law to exist, when the question is asked, we don't want this bill, then the question that must be asked, then what shall we do with disinformation? What shall we do with hate speech? What shall we do with disclosure of matters private in nature and the disclosure of which will cause trouble in society or will bring harm to some people? What shall we do with that? So it looks like there is the need. Unless if we say there is no need, then we want to keep laws such as Section 208 of the Criminal Offences Act. If we say there's no need, then it means we want to keep such laws as Section 76 of the Electronic Communications Act, which punishes up to 5 years. I know people who can explain that law properly to say that it is not about speech, but it has been used to criminalize speech. So there is the need. So if there is the need, then it means the attempt is important. But do we want this in its state? That is the question to ask. Again, what does the bill seek to do? as we talk about its promise. It says the object of this bill is to protect individuals, groups of persons, private and public institutions, and the government from harm, threat of harm, violence, fear, disrepute, discredit, embarrassment, harassment, intimidation, ridicule, unrest, panic, and disturbance of the public peace caused by misinformation, disinformation, hate speech, and the disclosure of private facts and publication of confidential matters concerning the Republic. A central question that arises is, there is a world of difference between misinformation and disinformation. In one, there is deliberateness to do something we know is not accurate, it is wrong. That is disinformation. In the other, there is no deliberateness. Often, there is no deliberateness. So why do you want to punish that? That appears to sit squarely within Section 208. Because Section 208 actually says, if you publish false news, it is not a defense to say that you didn't know that this will be that much. So it means, even without intent, you could suffer under that law. And this is the law we have been crying to be abolished and repealed, and it has not been repealed. Why are we bringing something that mimics the same thing? Disinformation, yes. Hate speech, because incitement to violence, incitement to disturb the public peace, hate speech, tribal, bigotry, in the nature that causes one tribe against the other. In this country today, we can see this happening on social media. But sometimes we underrate the potential of what such, speeches can do. So there's one tribe that says that against the next tribe, and people are actually setting up pages to promote hate speech and indecency. So the promise of the bill is good, but it has the perils. Because there's no time on my side, let me quickly look at one or two things, but the phone lines are open right now. You can join us with your questions, comments, as far as if you are also aware of this bill and what it does. In Section 3, subsection 3 of the bill, it says that without limiting the effect of subsection 1, the Act shall not be interpreted to usurp or limit the mandate of the National Media Commission. It says this law should not be interpreted to usurp the mandate of the National Media Commission, which is set up by the Constitution in Chapter 12, to be the one, to be the guardian of free speech as is published. But guess what? Once you get to Section 9, as far as the division that is set up is concerned, it says that where there is the division has to do something and there's some parallels as far as certain legislation is concerned, the division will have supremacy. You have usurped the NMC's mandate. You have usurped the NMC's mandate. Again, the regulator of platform everywhere, in the UK, if you talk about the Ofcoms, in Nigeria, in Kenya, and elsewhere, The regulator that, like the NCA, has no business in policing speech. They regulate the platforms, the telcos, the institutions. They have no business dealing with speech. But here, it's supposed to play this dual role. So you take away NMC's role. You've usurped it. Theophilus, you're calling us from where? Let's hear you quickly. Hello, Theophilus.
I'm calling from Bupi in the Savannah.
Go ahead with your commentary or question.
Okay, Samson, where I sit, I'm a strong advocate of free speech. I do not believe that someone should go to jail or someone should be in prison for speaking up their mind. And what I found very worrying about this, what I found very interesting about this particular bill in particular, is its attempt to repeal Section 208 of the Criminal and Other Offences Act. That is what I found very interesting about this bill. Apart from that, its attempt to criminal or to censor speech is something I strongly advocate against, and I think that it should be looked at. The second point is, yes, we can look at the disinformation bit. It attempts to criminalize disinformation, but misinformation, I do not see why someone can make it can make it fall.
All right, thank you, Theophilus. So I was actually looking for this particular section, Section 9, subsection 2. It says the division set up under the NCA. The division shall give effect to the directives of the minister where prescribed by this act or under this law. There's a part of it, 12, Section 12, Section 12, subsection, there's a subsection of Section 12. That is what I'm actually looking for. Subsection 2. It says, in the event of parallel roles between the division and any other public institution, the functions of the division shall prevail for the purpose of implementing this act. NMC is a constitutionally constituted body, giving the powers by the Constitution with institutional representation. The GBA, call them, the GJA, all of them sit in there. The Muslim Christian group, all of them sit in there. And this bill suggests that a division set up under the NCA with the director appointed by the president and the members so appointed can override the National Media Commission. That for me is troubling. Who do we have on the line? Hi, Nicholas. Hello, Lucas.
Yes, I'm listening.
Lucas, go ahead, quick.
Yes, my question is, I just want to understand misinformation and disinformation. Because I'm watching what my panelist is talking about. And he quoted a lot. I've understood him with what he's saying. But sometimes somebody might mislead. Is he wrong or is not wrong? If I do something in Ghana law, we all understand that somebody can say something.
Okay, so your point is made. I got it. Let's go to the next and last caller. Tony, hi, Tony.
Yes, please.
Yes, quick. Let's hear you.
Yeah. So something I have been watching right from the beginning till where you are now, and if I look at the expose, the 360 expose you've just done, basically, you clearly indicated that the focus of this bill is more like to censor, putting out facts that are not accurate. So, but it doesn't censor opinions. So if it's opinions, then you have no problem. But if you are putting out information that you claim it is factual, and it comes out later that it's not factual, it's not true, then I don't see anything wrong with this bill.
Thank you very much. Your point is made. Thank you very much. So that's the difference I was making to it, to help you to make your decision. But that is a part. It's not the whole. And the provision about the division I'm talking about, it says that the President shall, in accordance with Article 195 of the Constitution, appoint the division, appoint for the division other officers and staff that are necessary for the proper and effective performance of its functions. So that's where I ask the question, this is clear political control. And guess what? In Section 16, the minister has power to issue directives, and the division is supposed to comply with those directives. That again will definitely be problematic. And the sanctions regime, including revocation of licenses of media organizations and telcos and the rest of them, appear to be very hefty and will have a chilling effect on free speech. So we will take time and then get to deal with the bill in its various sections in much detail so we get to understand. Until then, commendable provisions seeking to repeal Section 208 of the Criminal Offences Act and to remove the jail sentence terms up to 5 years in Section 76 of the Electronic Communications Act. This is the law. It's your legal light. It is your help law.